Welcome back to the High Court Report, your one-stop shop for Supreme Court coverage. Today we discuss the 4 blockbuster opinions the Supreme Court released on June 29, 2026, Chatrie versus United States, Trump versus Slaughter, Trump versus Cook, and Watson versus the Republican National Committee.
Today's episode zooms past the individual case breakdowns, we'll hit each one briefly, and drills into the authorship patterns, voting coalitions, and cross-case themes that define what this court communicated in a single extraordinary day. We'll also close with breaking news. The court plans to release additional opinions tomorrow, June 30th. Almost certainly the final batch of the October 2025 term.
Before going further, here's your reminder to follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
All right, here's what you need to know. Let's run through the 4 cases fast, because today's real story lives in the patterns across them.
Starting with Chatrie. A man robbed a credit union in Midlothian, Virginia, May 20th, 2019, and walked out with $195,000. Police applied to a Virginia magistrate for a geofence warrant, a warrant ordering Google to hand over location data for every cell phone within 150 meters of the crime scene around the time of the robbery. That process identified Okello Chatrie as a suspect. Chatrie challenged the warrant on Fourth Amendment grounds.
The Supreme Court held that accessing his Google location history counted as a Fourth Amendment search, meaning police needed a valid warrant. The Fourth Circuit's ruling vacated and remanded. The warrant's validity itself still pending below.
Next, let's discuss Slaughter.
Early in his second term, President Trump fired the FTC's 2 Democratic commissioners, Rebecca Slaughter and Alvaro Bedoya, without citing any of the statutory grounds for removal. The FTC's statute only permits removal for inefficiency, neglect of duty, or malfeasance in office. Trump didn't use any of those. The court held that protection violates the Constitution. It overruled Humphrey's Executor versus United States, a 1935 precedent that protected FTC commissioners from at-will removal. District Court's permanent injunction protecting Slaughter reversed. Trump wins.
Now Cook. In August 2025, President Trump fired Federal Reserve Governor Lisa Cook, citing a pre-office mortgage fraud allegation. Cook sued, the district court issued a preliminary injunction blocking the removal, and the Trump administration asked the Supreme Court to stay that injunction.
The court refused, stay denied. Trump loses this one.
And Watson. Mississippi counts absentee ballots postmarked by Election Day, even if they arrive up to 5 business days later. The Republican National Committee argued 3 federal Election Day statutes preempt that.
The court disagreed. Federal law governs when voters cast ballots, not when states receive them. In other words, the Supreme Court upheld the process to count ballots after elections. The Fifth Circuit's ruling, which sided with the RNC, reversed. Mississippi wins.
Now here's where it gets genuinely interesting. Let's talk about who wrote what, because the authorship story today tells you something no single case could.
Start with the majorities.
2 justices authored majorities today. Chief Justice Roberts led with 2, Slaughter and Cook. Justice Kagan wrote Chatrie. Justice Barrett wrote Watson. Roberts alone accounted for half the day's majority output. Think of a referee who calls a foul on Team A in one play, then calls a foul on Team B in the very next possession. Same referee, same authority, different calls.
Roberts wrote the opinion that handed Trump a sweeping win over independent agency protections. Then Roberts wrote the opinion that blocked Trump from removing a Federal Reserve governor. Same pen, same day. Opposite outcomes.
And the concurrences?
5 concurrences today. The most authored across these 4 cases by any individual posture. Gorsuch led with 2 concurrences, one in Chatrie and one in Slaughter. Justice Jackson authored 2 concurrences, one in Chatrie and one in Cook. Justice Kavanaugh authored one concurrence in Cook.
And the dissents?
Justice Alito dissented 3 times, the most of any justice today, and the highest single justice output of any opinion type. He dissented in Chatrie, Cook, and Watson. Alito landed in the majority in only one case, Slaughter. Justice Barrett also authored 3 opinions but in very different postures, 1 majority, 2 dissents. She wrote the Watson majority, joined by Roberts, Sotomayor, Kagan, and Jackson, and dissented separately in both Chatrie and Cook. Justice Sotomayor authored 1 dissent in Slaughter. Justice Thomas authored 1 dissent in Cook.
So the full table looks like this, Roberts. 2 majorities, 0 concurrences, 0 dissents. Alito, 0 majorities, 0 concurrences, 3 dissents. Barrett, 1 majority, 0 concurrences, 2 dissents. Gorsuch, 0 majorities, 2 concurrences, 0 dissents. Jackson, 0 majorities, 2 concurrences, 0 dissents. Kagan, 1 majority. Kavanaugh, 1 concurrence. Sotomayor, 1 dissent. Thomas, 1 dissent.
And notice something in that table. Alito and Barrett tied for total opinions authored at 3 each, but Alito spent all 3 in the same posture, dissenting. Barrett crossed the entire spectrum, majority, then dissent, then dissent. No justice today covered more ideological ground in a single opinion day.
Let's talk coalitions, because the voting patterns tell an equally compelling story.
Start with the liberal bloc, Sotomayor, Kagan, and Jackson. Those 3 justices voted together in every single case today. 4 different legal areas: privacy, FTC removal, Fed Reserve removal, election law, and the same 3 votes every time.
They won 3 of the 4.
Won Chatrie, Cook, and Watson. Lost only in Slaughter. The bloc held perfect solidarity across an enormously varied docket, and that consistency makes them a reliable baseline for any coalition math on this court.
And Kavanaugh?
Kavanaugh serves as the fulcrum. Picture a seesaw, and Kavanaugh decides which side touches the ground. He joined the majority in 3 of 4 cases today. In Chatrie, he sided with Roberts, Sotomayor, Kagan, and Jackson, protecting Fourth Amendment privacy. In Cook, he sided with Roberts and the same liberal trio, blocking Trump's Federal Reserve removal. In Slaughter, he moved over, siding with Roberts, Alito, Gorsuch, and Barrett, overruling Humphrey's executor and giving Trump the FTC win. In Watson, he joined most of Alito's dissent, though not every section.
Kavanaugh sided with the liberal justices on privacy and the Fed, then turned around and sided with the conservative justices on the FTC, and his vote determined the outcome in the close cases. Roberts plus the 3 liberals gives you 5, enough to win in Cook. Roberts plus the conservatives gives you 6 in Slaughter, with Kavanaugh again in the majority. Kavanaugh's landing spot decided every contested case.
And Thomas took the most aggressive position of any justice today.
In Cook, Thomas dissented alone on the sharpest grounds. He argued that the Federal Reserve's independence itself violates Article 2, that the Fed's governors should serve at the president's pleasure entirely, same as any other executive officer.
No other justice joined that view, not even Alito or Barrett.
And the conservative bloc in Chatrie fractured 3 ways. 4 justices generally considered conservative: Alito, Thomas, Gorsuch, Barrett, and they reached 3 different conclusions in Chatrie. Alito and Thomas dissented outright, arguing no search occurred. Gorsuch concurred in the judgment, agreeing a search occurred, but through a completely different theory.
Barrett dissented separately on her own grounds. So in a single case, 1 outright dissent from 2 justices, 1 concurrence in judgment from a 3rd, and 1 separate dissent from a 4th. The right side of this court doesn't move as a block. It fragments case by case.
Now let's go deeper on the 5 concurrences, because each one previews the next constitutional battle. Start with Gorsuch in Chatrie.
Gorsuch agreed a search occurred, but refused to reach that conclusion through the Katz framework. Katz versus United States, The 1967 decision that established the reasonable expectation of privacy test has governed Fourth Amendment analysis for nearly 60 years. Gorsuch called that test unmoored from constitutional text and history. Here's an analogy. If someone steals your diary, you don't need to prove you expected privacy in it. You owned it. Gorsuch would ask the same kind of property-based question about location history. Does it qualify as Chatrie's papers or effects under the Fourth Amendment's actual text? If yes, the government searched his property. No Katz needed.
He reached the same result, but rejected the entire framework the majority used, and flagged that the third-party doctrine, the rule under Katz that says sharing information with a third party eliminates Fourth Amendment protection, produces absurd results.
Do Americans hold no privacy expectation in records their banks, doctors, or pharmacists keep?
Gorsuch said, if not, someone needs to explain why, on the basis of the Constitution, not judicial invention. Then Jackson and Chatrie, the other direction. Jackson, joined by Sotomayor, would have gone further than the majority in the other direction. Rather than remanding the warrant validity question, Jackson would call the specific warrant unconstitutional right now.
The warrant steps 2 and 3 left officers with no binding criteria for narrowing the device list. Just attempt to narrow down. No judicial supervision governed those steps. Officers initially sought data from all 19 devices and almost accessed all of them, until Google pushed back.
Jackson called that a roving commission, precisely the kind of unbounded officer discretion the Fourth Amendment prohibits. She told the Fourth Circuit to treat steps 2 and 3 with serious constitutional skepticism on remand.
So Gorsuch and Jackson pulled in opposite directions from the same majority opinion. Gorsuch challenging the privacy framework itself. Jackson arguing the majority didn't go far enough on warrant validity.
That's the architecture of today's concurrences in a nutshell. Gorsuch in Slaughter, same pattern, different case, agreed with overruling Humphrey's executor, but wrote to raise something the Roberts majority left completely unaddressed. Congress didn't just delegate enforcement power to independent agencies. Congress also gave them legislative and quasi-judicial authority, the power to write binding rules, the power to adjudicate disputes, the authority to impose hundreds of millions of dollars in penalties.
Now that the president controls those agencies, the president effectively controls all 3 types of power simultaneously. Gorsuch asked, would Congress have delegated so much authority if it knew the president would run these agencies? And what does the Constitution say about that concentration?
He didn't answer those questions. He planted a flag for the next round of litigation. Now to Cook, Kavanaugh's concurrence. 2 separate points. First, today's ruling doesn't decide Cook's ultimate fate. The court only established procedural and legal ground rules. The factual record on the mortgage allegation still needs development. Whether that conduct constitutes cause under the Federal Reserve Act, the courts need to resolve that after the facts develop. Second, and Kavanaugh made this explicit because the majority left it implicit, the Federal Reserve's independence survives Slaughter.
After overruling Humphrey's executor, the court needed to draw a line. Kavanaugh drew it at the Fed. The government itself conceded at oral argument that the Fed occupies a uniquely structured position in a distinct historical tradition. Kavanaugh called that concession binding. The Fed's 4 cause protections don't fall with the FTC's. If Congress wants to change that structure, it acts through legislation, not litigation.
And Jackson's Cook concurrence focused entirely on the equities, not the merits. Jackson joined the majority on the merits but wrote separately to say the application collapses on equitable grounds before the court even reaches legal theory. The government identified no irreparable harm from Cook's continued service, only the abstract assertion that the
president suffers whenever an officer continues over his objection. Jackson rejected that as a cognizable injury. Meanwhile, the balance of equities and public interests tilt heavily toward Cook. Fed independence protects the economy from inflation, price instability, and financial panic. Even the perception of political influence over the Fed can move markets. Jackson said, "The government missed the mark on equities by a mile."
So what does this actually mean, looking across all four cases?
3 major themes emerge.
First, executive power carries limits, but institutional context determines where those limits fall. In Slaughter, the president gained sweeping authority over independent agencies. In Cook, the Fed's 111-year history of central bank independence blocked Trump's removal attempt. Same legal framework.
Different institutions, different outcomes. Context doesn't just matter at the margins, it controls.
Second theme, judicial frameworks matter as much as final outcomes. Gorsuch spent both concurrences challenging the analytical foundations the majorities relied on. Katz, in Chatrie, the assumption that Congress intended independent agencies to function as the administrative state theorists envisioned in Slaughter.
Those aren't idle academic objections. They preview exactly where future cases will find traction. The next digital privacy dispute, the next challenge to agency rulemaking power.
Third, this court defies easy ideological labeling. Roberts authored 2 majorities and reached opposite results in 2 Trump cases. Kavanaugh sided with the liberals on Fourth Amendment privacy and the Federal Reserve, then turned around and joined the conservatives to overrule Humphrey's executor.
Barrett wrote the Watson majority alongside Sotomayor, Kagan, and Jackson, then dissented in Chatrie alongside Alito.
The coalitions shift case by case. Principles, not political teams, drive the outcomes. And one more thing before we close. Tomorrow. The court plans to release additional opinions tomorrow, June 30th. With 4 major decisions dropping today, the court moves toward the end of the October 2025 term. A handful of argued cases still likely remain on the docket. Tomorrow's release almost certainly brings the final batch. We'll cover whatever the court hands down. Same day, same format.
Stay tuned for that.
Bottom line from today, Chief Justice Roberts authored 2 majorities and reached opposite results in 2 Trump cases, distinguishing the FTC from the Federal Reserve on institutional and historical grounds. Justice Alito dissented 3 times, the highest single justice output of any posture today, and landed in the majority only in Slaughter. Justice Barrett authored the most varied portfolio, 1 majority, 2 dissents.
5 concurrences revealed where this court's internal debates run deep. The survival of Katz, the constitutionality of delegated power, the fate of geofence warrants on remand, and how long the Fed's independence truly holds. The term isn't finished, but today gave us a lot to work with.
Thanks for listening to today's High Court Report episode. Remember, please follow, rate, subscribe, share, and review the podcast on Apple, Spotify, YouTube, anywhere you podcast. Just search the High Court Report. And if you have questions about this case, reach out via LinkedIn or email at scotus.cases.pod@gmail.com.
And look, come back tomorrow. The court looks like it plans to release more opinions then. We'll cover them the same day. We always do. Think of us as your personal Supreme Court concierge, minus the robes and the lifetime appointment.
Talk to you soon.